Next, I'd like to call our next presenter. We're going to hear from Professor Cynthia Jones from American University at the Washington College of Law. Professor, good morning.
Good morning. So I want to talk to you about racial and ethnic disparities in the bail system. It is 100% clear from over 30 years of studies that current bail practices using money to set pretrial freedom have a disparate impact on the poor, and the poor are overrepresented by people of color. So to maintain the current system, you have built-in racism, and it is going to result in more black and brown people being locked up, and it's going to have a disparate impact on the entire trajectory of their case. Studies have shown that if you are locked up pretrial, you are more likely to plead guilty because you want to get out. If you plead guilty as a pretrial defendant, you are more likely to be sentenced to a period of incarceration, and your sentence will be longer than a person who was released pretrial. That's just data. And so you have set in motion, by holding a person pretrial, racial disparities that will reverberate throughout the entire life of the case. And that doesn't even get to what it's doing to the person's life outside of the criminal justice system, keeping them locked up away from their family, loss of housing, loss of jobs, and other opportunities. So one study, actually, and I believe it was a study completed by one of the other panelists who's going to testify today, showed that simply being black increases a person's odds of being denied bail by 25%. And being Latino increases a person's odds of being denied bail by 24%. That same statistic has been repeated in studies that were conducted in Ohio, in Connecticut, in Pennsylvania, in New York City. The problem is twofold. And before I get into why we have racial disparities in bail, we have to at least acknowledge that some of the racial disparities occurred before the bail decision even was made, right? There are racial disparities in policing that bring a disproportionate number of African Americans and Latinos into the criminal justice system. Bail could and should be the great equalizer, right? If the police officers are not doing their job and they're engaged in racial profiling and other unconstitutional acts, and they're bringing black and brown people into the criminal justice system, judges could say, we're not going to engage in tactics that exacerbate that problem. We're going to be the great equalizer and say, if you're not dangerous, if you're not a flight risk, you can go home, regardless of the color of your skin, regardless of wealth. Instead, bail is one of those discretionary decision points in the criminal justice system where we're not making good discretionary decisions. So there are two principal reasons for racial disparities. The first is fairly simple and has been already discussed by the other panelists. Black and brown people are disproportionately poor in our society. Black and brown people in the criminal justice system are disproportionately poor. They are too poor to make ends meet outside of the criminal justice system. They're too poor for a lawyer, and they're too poor to make bail. There are not many people who are college educated, who are honor students, who wake up and decide to commit a crime and end up in the criminal justice system. But those of us who are professionals, not one of us would be held in jail because we couldn't pay $1,000. We would get those resources. We have family members who would provide those resources. We would charge it to a credit card. We would get out. But for an overwhelming number of black and brown people, those funds do not exist. One case in a public defender representing a person in Maryland had a $20,000 bond on a first offender for a nonviolent charge, and the public defender was just elated when she was able to get that bond down to $300. And she went to his family and said, I got it down to $300, and the grandmother said, sweetheart, there has never been $300 in this house at one time, ever. I have no way. It might as well be $1 million. That's the reality of money bail on an overwhelming number of black and brown families. So What we have, in addition to simply racial disparities or the disparate racial impact that results from using money, separate and apart from that, that doesn't solve the problem. So even if you got rid of money bail today, you would still have racial and ethnic disparities in bail. And that's exactly where they were. They found this out in Charlotte, North Carolina. They had a huge overpopulation of people in their jail. They engaged in aggressive pretrial reform, and they reduced their jail population by 50%. They were excited and elated. But guess what happened? The rate at which they were locking up black and brown people stayed the same, because they only addressed the problem with bail generally, money bail generally, and they didn't address the implicit and sometimes explicit bias that happens in the bail determination process. Bail in America and in Chicago characterized by two central characteristics, both of which are harmful to racial justice: expediency and a lack of information. If you go to bail hearings, they're not viewed as a very serious point in our criminal justice system where we have to pause and make informed, intelligent decisions about a person's pretrial freedom. It is viewed as something you have to get through as quickly as you can and move along as quickly as you can. Spending less than a minute to decide that somebody is going to be locked up for weeks and months is injustice. That is injustice. And that's what we do. Bail decisions, in many places in this country, you don't have a lawyer. In many places in this country, when the bail decision is made by somebody based upon some scale, that becomes the truth, and nobody questions it. No one looks to see if you're an honor student, a veteran, 8 months pregnant, or any other thing that would suggest that you could be safely released back into the community and returned to court. So that expediency creates part of the problem in terms of racial and ethnic disparities. The other part of this is the profound lack of relevant information available to judges when they're making a bail decision. All of the things that your statute says judges should take into account when deciding bail. All of the things, if I just surveyed the room, that you would come up with on your own. Does the person live in this area? Have they ever been convicted of a violent crime before? Did they threaten any victims or witnesses? Do we have any reason to believe they have the resources to flee the jurisdiction? As a former public defender, I have to tell you, when my clients didn't come to court, it wasn't because they fled the jurisdiction. They didn't have the money to go anywhere. They weren't going anywhere. They were at their grandmother's house. They forgot. That's not what the bail was designed to prevent. Now, we have found, and I used to be the deputy director of the D.C. Pretrial Services Agency, the simplest, easiest thing that we did to get the return to court rate up to 90%, we telephoned or contacted everyone on release and reminded them of their court date. Very low cost. And we use sometimes college students as volunteers in their internship to make those calls, no cost. The easiest thing. So flight risk is not a legitimate concern for the overwhelming number of black and brown people. They want to come back to court. They're scared not to come back to court. And they're going to resolve those cases. So simply locking people up is not necessary. So when judges are making a decision about bond, they know a very few things about the person. They know what they're currently charged with. They know the facts that the police have alleged that they've committed. And they may know their prior arrest record in this jurisdiction, which we know arrest record can be deceiving in an era where we still tolerate a lot of racial profiling. But they know that information, and they know what the person looks like. If they don't know, and no one researches the person's background to see whether the person has a degree, whether the person is taking care of an elderly relative, whether the person has 5 kids, no one's checking on anything else, all of those relevant considerations. And so the judge is making a decision in the absence of that information. And what happens, what all of the studies show, is that in the absence of that relevant information, they rely upon implicit bias. And it may be that if you are a large African American man, you look like what that judge thinks a dangerous person looks like. I don't have any information on your background, and I've got to make a decision. And keep in mind, I've got to make it quickly, or at least I feel I have to make it quickly. And so in that snap decision, I resort back to money bail, and I say $50,000. If you are a Latino and you appear before a judge and no one has researched your background or your work history or your education history, and the judge has to make a quick decision and the judge knows what you look like, you may look like what the judge thinks is a flight risk. They may think this person's an illegal immigrant. They're not going to come back to court. They're going to leave and, go where every single Latino comes from, go to Mexico, right? They may make that decision and look at you and say $50,000 simply because you look like what they think a person who's a flight risk looks like. So even if you fix money bail, you have to deal with those implicit and sometimes explicit biases by the decision maker. And what happens is, one, you have to give them the information they need to make informed decisions. And two, those decisions have to be accountable. If you can continually in your job make decisions, discretionary decisions, and nobody looks at them, nobody examines to see whether you're making decisions and there's a pattern of racial and ethnic disparities, if nobody ever looks at and collects that data, then it could continue. Every study on implicit bias says when you have a discretionary decision maker and they know that their discretionary decisions are being reviewed, it changes their behavior. And that makes sense. And that makes perfect sense. So I would urge you, if you begin to reform your criminal justice system and look at bail practices, don't just get rid of money. Get rid of money and make sure that the discretionary decision makers, the judges who are deciding bail, have to provide a written justification of why they're holding that person. What facts are you relying upon to find that this person is a flight risk? Facts. What facts are you relying upon to find that this person is a danger to the community? And I would add one more fact. One more fact. Please, judges, make a factual finding of ability to pay. Because judges are allowed under the current system to come up with that random arbitrary number and never pay any attention to whether this individual has the ability to pay. And so maybe the judge thinks, I gave him a $500 bond. I assumed he got out. And again, if you're really poor, if you're homeless, that could be $1 million. So the current system that we have has to have, one, information to make informed decisions to combat implicit and explicit bias, and two, it has to be followed up with accountability. Somebody needs to take a look at these decisions that the judges are making and evaluate whether those decisions create a pattern of racial and ethnic disparities that need to be interrupted. Thank you.
Thank you very much, Professor Jones, for sharing your perspective on the role of race and the impact of systems like ours on people of color and poor people in particular. So thank you very much. Commissioner Sufferman.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. So of all the things in your background, I think the thing I find most intriguing is that you were the deputy director of this pretrial service. And we're struggling because unfortunately our state just doesn't properly fund. This is just something I will harp on completely. I just left a group of lawyers talking about how other parts of our court system are underfunded because of the way the state does it. What was the minimal kind of staffing that you felt you needed for the volume of people that you were dealing with? Because that's going to help us maybe figure out what we can do.
So I was the deputy director of the DC Pretrial Services Agency, both when it was a DC-funded, or shall I say underfunded agency, and I was there when it received the federal funding and the budget went way up. So the minimum level of, and so let me just also say that before the DC Pretrial Services Agency became this, premier Gold Star agency that is today, it started out with a lot of college student and law student volunteers. It was the best internship in town, and you have lots of colleges and lots of law students who can make those phone calls to remind people of court. Having people come down to the courthouse and check in once every other week and just have someone check in with them and then at that time remind them of their court date. Very low cost, and you don't require an army of people. So that the minimum level was mostly having people to do the assessment, and we don't use the Arnold tool in DC, but having people do interviews of the arrestees and verify some information and prepare a report to the judge. And then a very few, I would say less than 50 people who were in the supervision side of the house, some calling people and reminding them of the court date, and some doing referrals to get people into treatment and mental health services. And I noted that you expressed a concern about having that support in the community. And I would just say, before DC Pretrial had the federal money, they coordinated with other government agencies, and those agencies provided the services, and they got sort of priority placement for people in the criminal justice system. So pretrial wasn't funding all of the mental health treatment and all the drug treatment that everybody needed.
Unfortunately, you're in a state where we've shut down all of our mental health services, and it's very difficult to find beds for anybody who needs drug treatment. But just give me kind of the volume of people you had to the ratio of these this staffing. I mean, were you dealing on a daily basis with 2,000?
10,000.
10,000
At any given
on a daily
time,
basis.
there were
Okay.
10,000 people who were
Good.
on pretrial release and being supervised by this agency. And a good number, as Judge Morrison said, a good number of those people who were supervised, who were on release, were unsupervised. So there were no conditions necessary, and so there was nothing for pretrial to do other than call that person and remind them of the court date.
Yeah. You know, we can't change the bail statute. That's the General Assembly, and the General Assembly is unfortunately more dysfunctional than the federal Congress. So what we can do, though, is figure out how to get more pretrial services to at least say to our judges, we believe that you could release more people because we've given you this kind of safety net. And that's what I'm trying to get at. So it sounds like the way you ran the agency before federalization was probably where we are. But maybe we have a few more resources, but because we're 5.5 million people, and we're a large jurisdiction. So.
But all 5.5 million aren't criminals, so.
No. I hope not.
So you're not really trying to develop a system to accommodate 5.5 million people. It seems to me the starting point, and Judge Morrison mentioned there are lots of models, and the website, the Pretrial Justice Institute, is probably the best clearinghouse to look at where people are doing it effectively around the country. If you go to PJI, they will be able to help with that, .org. But in addition to that, I think building a system where you start off small, 50 or 60 pretrial services officers who are well-trained, and some jurisdictions start off by putting them in your existing probation office or putting them as part of your existing pretrial services agency, and they're doing supervision. And again, I know this may sound unrealistic, but there are people who are getting master's degrees in social work who have to do a practicum. So some people can assist free of charge and get their experience. It's not that it's extremely technical and difficult.